Good morning, Hearings and Appeals.
Good morning. My name is Marc Stevens. I have a hearing with the client this morning. His name is. We've scheduled for 9 o'clock.
Okay, he's already here, and at this time he's in the hearing.
Well, yes, I'm representing him at the hearing. I was trying to get through, and the number just that I had from the last time just kept on ringing. And then I called Miss Gonzalez, and that just went to her voicemail. So I'm trying to get connected to the hearing.
Okay, I'll connect you. Miss Gonzalez is not in today. However, Mr. Mascis, Andrew Mascis, is overseeing the hearing. Hold on, and I'll transfer you to the hearing room.
Thank you.
Hi, Lou. Hi, Mr. Stevens?
Yes.
Hi, this is Jay Mascis with the Comptroller's office. I'm actually here in the hearing room with Mr. Pittman and the Jim.
Oh, good.
Absolutely. Okay, I'm going to put you on speaker. Thank you. Hi, Mr. Stevens?
Yes, good morning.
Hi, good morning. Okay.
Hi, Marc.
Good morning.
All right, we're in the Comptroller's hearing room and in the Baltimore location. I'm not sure where you're calling from, but the area code doesn't look familiar. So let me see. To start out the hearing, I'll explain what the procedure is. Basically, what I'm going to have the Comptroller's representatives explain why the assessments were issued. If I have any questions of them, I'll ask. Thereafter, I'll turn it over to you to make a presentation. You can either start out with a presentation about why you disagree with the assessments, or you can ask questions as to why the assessments were issued. My job as a hearing officer, I'm an attorney in the state of Maryland. Basically, I review why the assessments were issued, review what you have to present, and make a decision one of three ways. Number one, that the assessments are completely incorrect, at which point I'll basically issue a closing letter, say, the assessments or your account has been down to zero. Sorry for your inconvenience. Thank you for your cooperation. Good day. The second decision that I could make as well, that the assessments are partially correct, at which point I would send you a settlement agreement, basically stating here's the tax, probably waive the penalties, may just look at the interest based on the tax circumstances. If we agree, then that's great. You can sign the return, and we do a lump sum payment or a payment plan, depending on the facts and circumstances. The third decision is that I could make is that the assessments are correct as stated, and at which point, depending on how I feel about the case, I may send you a settlement agreement if I think settlement's possible, or number two, I could issue a notice of final determination. A notice of final determination would state the facts, the law, apply the law to the facts, and give you a paragraph or paragraphs explaining why I might reach my determination. If we're able to settle, great. 95% of my hearings settle at this level. However, 5% do not. Let's see. If you get a notice of final determination and you read through it and you agree with what I wrote, you can still contact me and say, hi, Jay, I'd like to settle. If you read through it and you disagree, you do have 30 days to appeal to the Maryland Tax Court. Maryland Tax Court is located upstairs on the 15th floor. You do not need to be an attorney or have an attorney present to actually appeal to the Maryland Tax Court. Depending on the facts and circumstances, one may be helpful or not. Let's see. Thereafter, if you don't get the result that you like at Maryland Tax Court, you could petition to the Circuit Court or the Court of Special Appeals or Court of Appeals, or as far as you'd like to go. Let's see. The hearing will be recorded. We'll use a computer recording software. It's not recording now. If you'd like a copy of it, one's available for $4. You already thought you recorded, but you can always have an extra copy from us for $4. You would simply write me a letter and say, please, dear Jay, please give me a copy, and I'll usually give it to you within 30 days. So, let me see. We have 45 minutes allocated for the hearing. When can you expect a decision? Most of my individual cases are resolved within 30 to 90 days. That's a general time frame. That's not a statute or on 91st day that I have to issue it, but most of them are resolved within 30 to 90 days. Did you have any questions on the procedure?
I did. The reason why we're here today and didn't get it resolved a few months ago was because we couldn't get a responsive answer from, I guess it was Ms. Gonzalez, who did the hearing last time. She just absolutely refused to discuss basically the ground rules of the hearing. We wanted to know what the grounds were to have an assessment thrown out or determined to be completely incorrect, as you mentioned earlier, and we couldn't get an answer from her. So that's what we need to start with today. And we also need to make sure that, and I know that Ms. Barmuth called me yesterday and left a message that the one who did the assessments, Sion, I think her name is she present?
She is.
Okay, great. So as far as the other part, we were trying to find out, sir, what the grounds are for you to show that, say that an assessment was completely incorrect. And
I'm an attorney, and I can actually go over that with you today. So we're here. This is going to be a good hearing.
Well, great. I believe the last hearing officer claimed to be an attorney also, but she refused to discuss it.
Oh, okay. Well, I've got a copy of my Maryland bar license, and I promised you I'm an attorney, and I actually have documentation to provide you if you'd like. And I also can have a copy of the statutes, which basically give the authority to the Comptroller's office to issue assessments. So I'd be happy to discuss that with you today.
Oh yeah, I have no. I was not doubting that the last hearing officer was an attorney or not. I'm just, I was. The question was why, why she wouldn't answer a very basic question. So I'll put it. The question she wouldn't answer was, the particular grounds that we would have to show today to have you determine that the assessment is completely incorrect. Would one of them be that? Miss Sion, I think her name is. Can I just get for the record? Could someone please tell me exactly how to pronounce her name? I don't want to keep pronouncing it wrong.
Can you state your name? Sion.
Sion, like the okay.
Yeah. It's yes.
Okay, Miss Sion. Okay, the grounds that we were looking for in particular is that if we're able to show today that the assessment was not based on facts or evidence, is that grounds to show that the assessment is completely incorrect and should be abated?
Yes, an argument could be if Mr. wasn't a resident of Maryland at the time, if he did not receive wages, or that he didn't have any income during these years.
Well, what if we're able to show that there's no evidence he has taxable income?
Okay, well, yeah, that's something that you can present. Absolutely.
Okay, so I just want to be clear. So if it's shown today that she cannot show that there's admissible evidence or that there's facts to show that there's taxable income, then you would be able to determine that the assessment was completely incorrect and have it thrown out.
Yes, there are various types of non-taxable income that the Maryland law allows. So, yeah, if you can show that the assessment is based on non-taxable income, then I believe that would make the assessments go away. Okay,
what if we're able to show, because we have some evidence, because we've spoken to Sion before, and what if we're able to show today that, and she admits that she was not qualified to have made the assessment, would that be grounds to show that it's completely incorrect?
That would be a legal argument. And we can go over that during the hearing. Absolutely.
Well, before we do that, though, if the agent is not qualified to have made the assessment, wouldn't that be grounds to have it vacated?
I don't know. We'd have to do a review of the statute and the laws. We can do that during a brief overview during the hearing.
So this is a little confusing to me. I just want to nail this down before we start and have her put under oath. Would you accept an assessment from an agent that was not qualified to make the assessment?
I've never actually had someone make that argument before, so I haven't ruled on that issue before. I suppose that if the assessment was erroneously issued, then it would be rescinded. So I guess the answer is yes.
The answer is yes. Great. Because the way I look at it, just a quick analogy, because you're saying you're not familiar with this, is I look at what Sion did, or Sion. It's very similar, if not exactly the same, really, as when a police officer writes a ticket. And you go into court, she wrote an assessment, an accusation against Mr. and she's saying he's a taxpayer with taxable income. And then if we go into court and that police officer is not qualified and actually is impeached as a witness, then regardless of how much the judge wants to find my client guilty, he doesn't have a qualified witness to base it on, so it's just thrown out. And so that's that, because what we've done in the past, what we've already done is we have on Miss Sion on record as saying that she was not qualified to say that Mr. had taxable income.
Okay, I would save that argument for the hearing. Let me actually start the hearing first before you would go into make the actual substantive arguments. Did anybody else have any questions on the procedure? Nope. Okay, I'll start the hearing. Basically, what I'm going to do is I'm going to read a short statement into the record, basically identifying who's here and what we're talking about, and the tax years and where we're at, and then I'll read this hearing is under oath, so I'll basically ask everyone that is testifying to raise their right hand. Mr. Stevens, you don't have to raise your right hand or over the phone. I'll assume that you're doing that. And
well, I won't be offering actual testimony, and neither will Mr. today.
Oh, okay, Mr. won't be answering. Okay. So where is area code 602, by the way?
Oh, I'm in Phoenix, sir.
Oh, Phoenix, okay. Well, I bet you're having nicer weather than we are right now.
75 degrees in January? Yeah.
Yeah, I worked with an attorney out in California. I was out in California for a while, and that summer heat, 110. It's a dry heat, but it's still 110.
But it's 75 in January.
I love it. I love it. That's... Got tracking number 6801. And we are recording. Okay, this is an informal hearing being conducted on January 26, 2011, before the Comptroller of Maryland in the Baltimore office. At issue is tracking number 6801 in the matter of representing the taxpayer is Mr. Dennis.
I'm going to make an objection to characterize my client as a taxpayer at this point, even before we've had a hearing.
I will note your objection. Representing Mr. Is Mr. Jim, and Mr. Marc Stevens. Representing the division is Edna Anderson and Sion Beakley. The designated hearing officer is Jay Maskus. The case involves tax due for tax years 2000 to 2002 and also 2004 to 2009. This resulted in assessments dated, I believe, September 29th, 2010. Okay, if you're testifying, please raise your right hand. Do you solemnly declare under the penalties of perjury that the testimony you're about to give will be true and correct to the best of your knowledge, information, and belief? Okay, and I'd like to note for the record that Mr. did not raise his hand, and Mr. did not raise his hand, and Mr. You are not raising your hand or not swearing under penalties of perjury either. Mr. Stevens, I'm sorry.
Right, I am not testifying today.
Okay, so, all right. Ms. Beakley, there were some assessments issued against Mr.
Well, I just want to I want to ask you a question, sir, before we get started.
Yeah.
Now, you said we had, and we have Sion. Who is representing the department today?
It is Sion and Edna Anderson.
Edna Anderson. And as far as your role in this, sir, who are you representing?
I am a hearing officer. I'm employed by the Comptrollers of Maryland.
So you actually are working on behalf of the, let's say if there's like two parties to this, we've got my client and the department. So you're actually working on behalf of the department.
I work on behalf of the department. I receive a paycheck from the Comptroller of Maryland. My role in this is decide the case based on the Maryland law, the Comptroller's policies regarding issues, and basically to make a judgment on the facts and circumstances that are present.
Do you believe? Would you believe that there was a conflict of interest and that you're actually getting paid by the other party to this, who's actually bringing an accusation against my client?
My role is to review do I feel that there's a conflict of interest?
Yeah.
Let's see. Do I feel that there's a conflict of interest? My job is to provide a hearing. This is the initial hearing. I am paid by the Comptroller, so I have to espouse the Comptroller's policies on this. So if your policy views toward a certain issue are at odds with the Comptroller's, then I suppose there would be a conflict of interest, yes.
So how can Mr. Palm really get a fair hearing if there is a conflict of interest that we've already established?
My job is, well, if I rule against Mr. he has the ability to appeal that to Maryland Tax Court. Well, and Maryland Tax Court will review the case de novo, meaning that they are not employed by the Comptroller of Maryland. So he does have an opportunity to review, appeal my decision. Therefore, I believe that the due process, both procedurally and substantive, constitutional requirements are satisfied.
Well, is he entitled to a fair hearing?
He is entitled to a fair hearing.
Can he get a fair hearing if there's a conflict of interest?
I will give him a fair hearing.
Well, that's not what I'm just asking you a general legal question. I mean, if there's a conflict of interest, can he get a fair trial, a fair hearing?
I think he can.
With a conflict of interest?
I believe, yes, he can.
Well, let me ask Ms. Anderson a question. If we were having a hearing and they were making these accusations against Mr. Palm, and Mr. Palm was paying somebody to make a determination, would she have a problem with a situation like that? Would she make an objection or think that her client may not be in the best situation?
I'll rephrase it. If you were in Mr. Palm's chair, if you were in there and Mr. Palm was basically testifying to facts, and the person that was arbitrating was employed by the same person as Mr. Palm, would you find that to be it was a conflict of interest or a?
Yeah, conflict of interest, obviously.
If you were, that's what Mr. Stevens' question is. That if you were in Mr. Palm's shoes, would you find that you would be able to get a fair hearing?
Yes.
Yes, the answer was yes.
Wow. Well, maybe that's something we can do if we don't resolve this today, that we can actually go to a private mediation where Mr. is paying the mediator, and then we can sit down and we may be able to get it resolved that way, since she wouldn't think that would be a problem. But, all right, I think
Maryland law does not provide for a private mediation. It does provide for an administrative an appeal hearing, which this is, and then it also provides you to appeal to the Maryland Tax Court, which is, again, not there's no interested party, or the arbitrator is absolutely neutral.
Well, that's not actually true, because how does the Maryland Tax Court individuals and judges, how are they paid? Are they paid for money that's collected by the Comptroller's office?
They are paid, but paid out of tax money.
Yeah, but they're paid out of tax money that's collected directly from the other party to this proceeding.
Yes, and then if you did not receive the decision that you wanted from the Maryland Tax Court, you could also appeal to the Circuit Court. And I guess your argument would be that, well, the Circuit Court judge is paid out of tax money, so they're not neutral either, and therefore the Court of Special Appeals, if you didn't get the result there, that they would be paid out of tax money, so they wouldn't be neutral. And then the Court of Appeals and the Supreme Court justices thereon would be non-neutral parties. Am I correct?
Well, right. You've already admitted. I think we can show it's not necessarily an argument. It's just an observation that there is a conflict of interest there. Everyone who's making a decision has a direct financial interest in the outcome of the matter. That if they rule against the department, they're not going to be taking money from my client that will then pay their salary. So I think the important thing is we've already established that there's a conflict of interest here. So we do object to that, but there's nothing we can do about it at this particular time. But we would just like to object to that now.
It is duly noted. Duly noted. Okay, so there's your basic argument, there's no possible way to actually get a, well, I guess you're saying that every government employee has a conflict of interest.
Well, I think we've established that you've agreed that you have a conflict of interest, and if you have a conflict of interest, then I don't see where, when we go up the chain of command, so to speak, that that conflict of interest can ever be resolved. That the only way to resolve that would but I'm sorry, hurry up, Jenny. I've just got a brief interruption. I apologize for that.
Stevens, you take your time.
No, I'm ready to go.
Okay. So we've established that there is no possible way for you to get your client or Mr. to actually have a, in your opinion, a fair proceeding because of the proceedings are held by government, and therefore a government employee, because they're actually receiving tax money, whether at the state, local, or federal level, that they have a conflict of interest there. So.
Right. Well, yeah. Right. You've already agreed that there's a conflict of interest. The only problem disagreement we're having is, I don't believe that my client can actually get a fair trial or fair hearing with a conflict of interest. You think that you still can, and you might actually be very fair, but that's to be seen.
Yeah, my job is to review the Maryland law, review the comptroller's policies on an issue, and basically, if the facts are for the, well, now again I won't, because I'll say if the facts are for Mr. Then I'll rule in Mr. favor, and I have, as I said prior to the hearing, only I think 95% of my cases are decided or ruled or resolved at this level, and 5% goes. So I have a good track record. So
okay,
all right. So let's go with the. So I'll make that. I'll note that argument. What would you like to have Ms. Beakley testify or state anything on the record?
Well, before that, I want to just give basically a short opening statement. I don't know if Ms. Anderson would like to do that.
I think Ms. Beakley has an opening statement that she would like to give. Or did you want to give an opening statement or her?
I will yield the time to her.
Okay. All right, Ms. Beakley. Could you?
Oh, we've done this before.
Okay.
But I'll do it again.
All right.
So wages for the above for Mr. For reference tax years were reported to the state of Maryland under the above tax regime and Social Security number. However, no tax returns reporting this income could be located. Letters were sent to request the returns or legitimate the reason why the returns were not filed. Taxpayer did not respond with that.
Objection. Assumes facts not in evidence. She's referring to my client as a taxpayer.
Okay, thank you very much. All right, could you continue reading?
Therefore, estimated tax statements were generated per Article 13303 of the Annotated Code of Maryland.
Okay. Just there was something that you had said that you had done this before. I was handed the. Let's see. I have the file. Was there a prior hearing or a prior attempt at a hearing?
There was a prior hearing.
There was a prior hearing on the same issue. And
well, there was a prior attempt at a hearing, and this is what I mentioned, that we weren't able to get to the actual hearing because the prior hearing officer refused to discuss with us what the grounds would be to vacate an assessment. And so it took so long going back and forth trying to get her to answer us that it had to be rescheduled. That there was no hearing prior to this.
There was, so you did show up, or someone showed up?
Oh, we were all present, yes.
But there was never actually a hearing because I don't know any of this. So
No, there was a full hearing.
There was a full.
There was a full hearing.
And this has been scheduled again.
As Marc said, we came to discuss the hearing, but we never got into any of the facts because we couldn't get the prior hearing attorney to stipulate what the grounds were for vacating the assessment.
All right. Okay. So let me see. Now that we've got with the hearing sheet, am I correct that? How did you wages for the above referenced tax years were reported to the state of Maryland? Can I see your testimony sheet? Mm-hmm. Wages for the above referenced tax year reported to the state of Maryland under, and I'll say Mr. name and Social Security number. However, no returns reporting this income could be located. Letters were sent to request the returns or a legitimate reason why the returns were not filed. The taxpayer did not respond with a valid
Objection.
Mr. For the sake of argument, Mr. did not respond with valid information or documentation. Therefore, estimated.
Well, that's an objection. I'm going to object. That's misleading.
Okay. Do you dispute that there was valid information or that there was not valid information?
We're disputing that it's not truthful that valid information was not provided to show that there was no taxable income and that there was an obligation to file. We did do that, and we have a recording with Sion to show that. We did it in writing, and instead of addressing those issues, they went ahead and did an assessment. They never responded to the issues and the facts that we raised.
Your objection is duly noted. Let's see. And I'm holding in a copy of. This is from our. Where is this copy from?
From Smart.
So this is from Smart. And Smart is the
state's official computer system.
It's a computer system, and to backtrack, and I'm going to, as I said prior to the hearing, I was going to start out with Ms. Beakley giving testimony, and then I'm going to, ask some questions here to try to get in my mind how the assessments came to be. All right. Your name is Sion Beakley, correct?
Yes.
Okay. Are you employed by any company, agency, person?
I am employed by the state of Maryland.
You were employed by the state of Maryland. How long have you been employed by the state of Maryland?
3 years.
3 years. Is there a specific agency that you work for?
Yes.
Yes. You work for the Comptroller of Maryland. Is that correct? Okay. How long have you worked for the Comptroller of Maryland?
3 years.
3 years. What are your general job description and/or duties with the Comptroller of Maryland?
I work for the compliance unit. I research non-filer cases. Sometimes I'm given cases. Sometimes I come across them. Other cases, and there is a list of things I need to check before I make an assessment, and I demand the taxpayers to.
Objection.
Okay. She was talking in general terms. She wasn't actually talking about Mr.
Okay.
Sometimes I get information through our system or the federal computer system that we have, and I collect this data and make a decision on whether a citizen is subject to income subject to tax or not. And I send letters, and they do not respond, or according reason how I collected those data, then I go forward and attempt to collect tax.
Okay. Are you familiar with Mr. Have you had conversations with Mr.
Yes.
Were you the person or the employee of the Comptroller of Maryland who issued assessments against Mr.
I was.
You were. How did you come to find out, or what was the basis for the assessments?
Well, I guess 2003 we received the information from the federal government that our return was filed for 2003, and then we looked in our database and found the other income.
Okay, and the database that you're referring to is the SMART system.
Right, but the initial information that we received came from the IRS for 2003.
Okay.
How did that information get into the SMART system?
The employer reported it.
The employer reported it. And from which state?
Let me see. Well, we'll get into this. These are printouts. These printouts that you just handed to me. These are printouts from the SMART system, and they list a Social Security, a tax year, a federal ID for a company, and it says source tape. Dennis M. Putnam Incorporated, 816 Seneca View Drive, and 220 AL. Gaithersburg, Maryland, 20882, Dulles, Virginia, 20116, federal taxable wages, 113,470 and 70 cents. Federal withholding tax, $14,120.76. And then it states on this computer printout, Maryland taxable wages, $113,470.70. Maryland withholding tax, 0. Maryland state pickup amount, 0. And there are several printouts in here for tax years that you've handed me. Are there additional information that is similar to this on the SMART system?
This is the only thing we have in SMART, but we do have other information.
Okay.
For the supplement and the tax.
Yeah, and then I can give you a copy of this if you don't have one already. I'd be happy to. This information is, where does this come from, to the best of your knowledge?
Mr. Former employer, I don't know, I believe.
Okay.
So Marc put the records in there?
Did they? I think they're, from my off the top of my head, I think that they're required under law to report information.
Okay, so report information, and then who entered the information into the computer system?
I think it's a computer system. It's actually, I think it's a computer reel, so it's one computer to the next.
So you're saying a line sent the computer reel to the state of Maryland, and that's how this information got entered into the system?
That is correct.
Okay.
Okay.
Marc, do you want to ask any questions at this point?
Would you like any questions on this data?
Oh, I had initially started. I thought Ms. Anderson was going to make an opening statement, and I would have done that and got to Sion's testimony. But one of the questions that I have are: Did AAL make any determinations that Mr. was a taxpayer?
The information that has been provided does not state whether he's a taxpayer or a citizen or an alien or whatever the terminology may be.
Is there any indication that AAL made legal determinations that he had taxable income?
There is no there is no indication that it made a legal determination that it was taxable wages. The information that I'm sitting in front of me states that it's federal taxable wages, federal withholding tax, and then Maryland taxable wages. Whether or not they actually had any support for their determination, it doesn't state on there.
Is there any evidence on there to indicate that they did this as a voluntary act, or that or is there evidence to show that it was done because the law required them to do it?
There is no evidence on this report that it was voluntary or involuntary.
Okay. Does Sion believe that this is something, or do you believe that this is something that AAL had no choice? They had to do this?
Do you think there was a requirement for AAL to do this?
I believe there was a valid requirement.
I think. Okay.
I'm sorry, I didn't understand what she said.
I believe there was a valid requirement as stating that they paid wages.
So it's compulsory for AAL to make these reports?
To the best of your knowledge, is that correct?
Yes.
To the best of her knowledge, that is correct.
Okay. So it's no indication that AOL made legal determinations that they were these financial transactions constituted any kind of taxable income. They were just doing what was required of them.
You are absolutely correct. There was no. Well, I don't know if the evidence that I have in front of me doesn't indicate that they made a legal determination. They may have made a legal determination prior to sending the information that they were federal taxable wages, but the information in front of me doesn't state whether or not they made a legal determination.
Okay.
So,
did you have anything else on that?
Yeah, the only other question I have is, would AOL have the qualifications to determine whether that was Maryland taxable income?
The evidence in front of me doesn't state whether they had qualifications or it doesn't state that. Okay. So let me get back to Ms. Beakley's testimony. The assessments that you issued, were they based on the filing of a tax return?
No, they were based on the income.
Okay. Would you and the income, the figures that you used to determine Mr. Burnham's income, did you rely on these?
Yes, I did.
Yes, you did.
Okay, so now my question is, how did you rely on that for the years 2005 to 2009?
How did you use that? I like that. How did you use that for 2005 to 2009? Did you actually have any W-2s in the system?
Yes, I believe for between 2002 and 2004, I had actual income in the system. So I collected added data from the federal information we had, and as we normally do, I took the highest income and doubled the tax.
Okay. And you doubled. So you took the last piece of information that you had regarding income, whether it was legally taxable or not, was 2004, and you didn't have any information for 2005 to 2009. So you took his. Is this? I think this came from you. This is a little scratch note. So you took his information and basically
doubled.
Right. But a determination was made that he was, based on our research, that he was still a Maryland resident.
Okay.
Maryland resident.
All right.
But you had no actual data to support what you assessed.
You didn't.
You just took a guess.
It was not a guess.
It was
just a guess. Okay. You had no actual data. Is that correct? You had no actual data from anyone indicating that I had any type of income, whether taxable or not.
That's not correct.
That's not correct. What evidence? What data did you have? What evidence?
For some of the years for which I already had income.
I'm talking about for the year 2005 to 2009.
Let's take for 2005. What'd you base the 2005 assessment on? Was there a...
2005 was based on the cost of... I did the cost of living based on the 2004.
Okay, so you took... So if I'm reading this, if I'm understanding you correctly, you took the income that was shown on this piece of paper, and you applied a cost of living adjustment index, where... And you basically increased his income for that 2005. Did not have an actual piece of evidence or data that said Mr. had 114,000 or 4,000 or anything like that.
Right. So basically, what I'm trying to establish here is that this is an estimate and a total guess, which, to my mind, constitutes a form of fraud, because she has no actual evidence of anything indicating whether I had any income at all. I could have had zero.
Okay. So, all right, you passed me a copy of the statute for 13402, and so you didn't actually have any evidence of his income, wages.
I'm not disputing the law here. I'm disputing the evidence. Okay. So there was no actual evidence, and this is what I'm trying to get from Theon.
Okay.
You had no actual evidence of years for 2005 to 2009 of any income whatsoever. You had no reportable...
Correct. The only evidence that I had is that you were still a Maryland resident.
Okay, we've established that.
Whether I'm resident or not, I'm asking a question about...
You're right.
We've established it.
Okay.
We've established it, that you did not have any evidence for 2005 to 2009. And so you provided me with a copy of the Tax General Article 13-402, and it said, subsection A, if a notice in demand for a return is made under 13303 of this title, and the person or government unit fails to file the return, the tax collector shall, and then you've highlighted subsection 3 of that, for income tax, estimate income by using the best information in possession of the tax collector. And 2, assess a tax not exceeding twice the tax due on the estimated income. All right.
So basically it says there, to the best of our knowledge, and to the best of our knowledge from what I've been able to establish, is that they had no knowledge at all. So according to what I understand from reading that, there is no knowledge.
All right. That's the let's see. Did you send Mr. the notice in demand for a return?
Yes, I did.
Okay, you did that. Is there any well, actually, hold on. If a notice in demand, you sent him a notice in demand, did you receive a tax return from Mr. in response to that? What years did you send a notice in demand to Mr. for?
Please indicate the date.
All right. You sent a notice in demand for tax year 2000, 2001, 2002, 2004, 2005, 2006, 2007, 2008, and 2009.
And when did those demands go out?
Let's see, is there something...
7/26.
That's my birthday. Isn't that nice? Let the record reflect the notice and demands were sent on July 26, 2010.
Yeah, I think that was only for year 2003.
And there was, just to be clear, I noticed that there was a gap in here. Was there any request for any documentation for 2003?
No, that was already on file that came from the IRS.
Okay.
So,
that was information received from the IRS. Okay.
Non-file.
Okay, so you had you made no notice and demand for it. All right.
Well, Mr. Damascus, before we go any further, I should have asked this before. As far as the assessments, as a hearing officer today, are you presuming any of the assessments as correct? Is there a presumption of correctness?
Well, I personally don't presume any assessments are correct until I actually get into the hearing or actually hear the facts and circumstances.
Okay.
There is a burden statute in the Maryland Annotated Code. I think it reads something to the effect of after an assessment is issued, the burden is upon the taxpayer, which you're going to object to because you're going to say, Mr. is not a taxpayer.
Well, there's no evidence that he is. And so that's what I'm getting to, because this is something we discussed with Sion on the phone, that they believe that under Section 13402, that once they make the assessment, it is automatically presumptively correct, and the IRS holds the same opinion. However, the courts have ruled consistently that the presumption of correctness does not attach unless it can be demonstrated it's based on facts. So at least for now, for 2005 to 2009, I'd like, at least for those particular years, a statement from you on the record that these are not presumptively correct and the burden has not shifted to Mr.
I cannot give that to you until you said you had court opinions. I would like copies of those court opinions.
Okay. Not something I can give right now.
Okay.
I guess it's just basic common sense tells you that if they are making a guess, it should not be presumptively correct. That without having to actually go to Adamson versus Commissioner, which is an IRS case, we shouldn't have to point to that to say they don't enjoy a presumption of correctness if it's arbitrary when they're not basing it, when they're admittedly not basing it on any facts.
USSC Portillo and Janice.
All right. I have not had an opportunity to review those cases. If you can send me a citations to those, I mean, I can look them up on Westlaw, but until I actually see a court case or actually able to read it, I can't agree with you, and I can't make that statement.
Would you maintain a presumption of correctness on 2005, even though it's admitted that it's not based on any evidence?
I'm not here to. I don't presume that it's correct at all.
Okay.
I'm here to basically rule whether it was correct, incorrect, or somewhere in between. So.
If you don't have a presumption of correctness right now, then I think that's good for now.
All right. So I have a copy of the statute. It sounds like that you're aware of Tax General Article 13-402, and okay. And so you have read it and you're aware of it. I don't think there's any dispute on that. Okay. All right. Let's see. Well, okay. I understand where the assessments came from. Ms. Beakley, if I can summarize, and I don't mean to put words in your mouth, that there was information from the IRS that arrived at the Comptroller's office, and if I can maybe make a point of clarity, how does that information arrive from the IRS to the state of Maryland? Did you call them up? Did they send an envelope? Did they send a card to you?
It comes through a computer system.
It comes through a computer system. So that computer system is IRS to state of Maryland. And, okay, did you request that information personally, or did it just come to you?
Oh, it comes generally as any other information would come.
Okay. And then you would testify that this information is available on the Comptroller's computer system, that it was reported to the Comptroller by the American Online, and I'd be happy to give a copy of that.
Yes, I have another question here. So you received information from the IRS, right? It's a computer record. Did you speak to anybody who made any determination as to whether or not I have taxable income?
No, sir.
Okay, so that was basically straight data, with no determination on anybody's part as to whether or not that income or that reporting of that transaction was taxable.
Okay.
Correct.
Okay.
All right. We've established that this is merely data. It doesn't state that there is has been a legal determination prior to or at the time of the submission that it's taxable income, which I guess leads me to the question of, well, how come? Why did you determine that Mr. Had a legal filing requirement, or that he was owed taxes to the state of Maryland? I guess I'll break this down. I can read from the data here. Why did you assume that Mr. was required to file a tax return?
Well, first of all, I did not assume.
Okay.
When I got this information, like I normally would do, I sent a letter to Mr. Putnam requiring him to please file, and if he does not believe that he's required to file, then send us any documentation to prove that.
Yeah.
And he didn't within the time he was given. But based on that,
no, I'm going to object. That's not true. We did respond. We actually spoke to Sion on the phone.
Okay. All right.
And we did follow that up in writing. And as I stated before, sir, I don't know why she continues to try to mislead and and skew the facts, as it would. We've already explained we did timely respond. We were on the phone. We have a copy of the phone call. We followed up in writing, and Mr. has, I'm sure, to have the documentation there to show that that Sion is not being accurate.
Okay. Did you receive any response or correspondence, letters, mails, emails, telephone calls from either Mr. Stevens, Mr. Putnam, or Mr. here?
Yes, I received phone calls, several phone calls.
Several phone calls.
I don't remember exactly.
You don't remember exact dates and times, but okay. Yeah. All right, that's good. There was some phone calls. And you made some phone calls to Ms. Beakley?
Yes, I mean, Mark and I both spoke to her, and I think Mark spoke to her once or twice besides myself.
Okay.
So we did respond to the thing, and questions were asked at Sion as to how she was making the assessment and so forth, and the assessments were made, and we never got a complete determination before the assessments were made, so I think that everything was done prematurely.
Okay. All right, so there was correspondence or phone calls. What information, I guess I know what point I'm trying to drive at.
When I was hired to do this job, I was told to assume that this particular information, the consular system, would be considered taxable income.
Okay.
I'm going to make an objection. Miss Sion had taken exception to when you stated that she did not, she said, I did not assume. Now she's saying she did assume.
Okay. We'll drop the word assumption.
Well, I don't believe we need to drop the word assumption, because I think a lot of what we're doing here is separating assumption from fact. And if she's going to be making assumptions, I believe that's going to bear on the validity of the assessment that she made, because we've already shown that there's no data whatsoever for 2005 to 2009. So I don't think we need to drop the word assume. I just think we need to be consistent. Okay. That she should not be objecting or taking exception when you use the word, and then she's going to turn around and and use it herself to describe what she did.
Okay, assumption is the word assumption is duly noted on her testimony. Let me phrase it. Let me ask you a series of questions and try to drive at what I think what occurred here. When you receive this information, what is it says? What is the information that's stated on that computer data?
I'll just use the
what's under it
in front of me. For 2004, it's stating that American has given $115,000.
Is there an address on that piece of paper?
There's a Gettysburg address.
Can you read the address on there?
8116 Gettysburg, Maryland, 2882.
Okay. If when you saw that address on there, and you can, I'm going to use the word assume. Did you assume that if there is a Maryland address listed on there, that Mr. lived in Maryland during, let's say, 2004. It looks like the address is on for 2004, 2003, and 2006. Did you assume that if his address was a Maryland address that he lived there?
I did.
You did. Okay. So there was a...
Well, I want to make an objection here. I don't know if what's being done here word-wise, because a lot of this is a word game. Is it being...
Okay.
Is it...
I can do believe, or I can do did you think... did you believe?
Well, I want a clarification on what you mean by Maryland. Are we talking about Maryland, or are we talking about the state of Maryland, as if they're synonymous?
The state of Maryland. It's not a. There's boundaries, line boundaries. There's a charter. The state of Maryland. Did you live within the? Did you believe or assume that Mr. was physically located within the state of Maryland during 2004, 2003, during 2002, during this time?
I believe so. Yes.
You believe so. Okay. So, to your knowledge, if a person is a Maryland resident and there's some data whether or not there was a determination beforehand as to the legal facts.
I'm going to object to the question because you're jumping now from a physical location to whether someone is a resident of the state, and whether someone is a resident of the state is a legal determination, and at this time would be assuming facts, not in evidence.
Gotcha. Okay. Well, I would actually go over to and ask Mr. whether he was a resident or lived in Maryland, but he didn't actually take a swear under oath that he was going to testify anything, so I don't know that. If he would like to swear under oath, I can certainly ask him whether he lived in the state of Maryland or resided in the Maryland.
Well, I would offer, as after speaking with Sion on this particular issue, that there's no evidence, just like for 2005 to 2009, there's no evidence that Mr. is in fact a resident within the state of Maryland.
Okay, you offer that there's no but that's an argument. And
well, I'm not necessarily, I'm just making an observation based on my personal experience with Mr. and Sion, that there is no evidence that Sion has presented to this up to this point to show that my client is in fact a resident within the state. It's just an observation that they haven't presented any evidence to that effect.
Okay. So I think I'll cut to the chase. Basically, Ms. Beakley, you saw this information. It said listed wages on there. It listed a Maryland address. So based on that information, she made a determination that the wages on here were taxable, and that Mr. either resided or was a resident of Maryland. Therefore, the assessments were issued. Is that a fair statement?
Correct.
Okay, that's a fair statement. That's why she did it. And I'll turn it over to you in full force to dispute that assessment was done incorrectly. So, Mr. Stevens or Mr. You can certainly go.
Well, thank you very much. Sion.
Yes.
Do you remember the phone call that we had together? I believe it was October 13th of 2010. Do you remember the initial phone call that we had?
I remember several phone calls. I cannot tell you exactly which ones was what.
Well, okay, well that's fine. But the initial phone call that we had, it was myself, you, and Mr. on the line. And do you remember me asking you about witnesses?
Yes, something about witnesses.
All right. Do you remember? Do you recall stating that you and the department do not rely on witnesses?
Correct.
Correct. So at this time, you agree that there are no witnesses with personal first-hand knowledge that Mr. is a taxpayer with taxable income and an obligation to file a return.
There are no physical witnesses now.
Okay, so there are no witnesses. I want to just be clear. There are no witnesses with personal knowledge that my client is a taxpayer with taxable income and an obligation to file a Maryland tax return.
Correct.
Thank you. Do you remember when I asked you about admissible evidence that there was taxable income?
You may have. I'm not really sure.
You may. All right. Well, we have Mr. May actually have to go under oath to testify to that particular aspect, but we do have a CD available of the phone call to prove that. And I was actually on the call also, so I'm a witness to that also. I remember asking you if there was a factual difference between income and taxable income, and you were not able to answer that. Do you recall that?
No, I do not.
You do not. Do you recall stating that no one at the department that you worked for could determine that the income was taxable?
I don't remember stating that, but if you would like me to answer that question again, I would be more than glad to answer.
Well, do you believe that you're qualified to determine that Mr. taxable income?
I am not authorized to.
You're not authorized to determine he has taxable income?
Appeal rooms.
I'm sorry, you spoke over me. You're not authorized to determine Mr. has taxable income?
No, I'm not authorized, in fact, but I can make assessment.
But doesn't the assessment include? Doesn't the assessment mean you're making a determination that Mr. is taxable income?
Okay.
I think this is a play on words, honestly.
Ms. Anderson, could you speak up and just state what you just whispered to Ms. Beagle?
The Kelly made the determination that Mr. income was taxable based on the W-2s in our system. It lists federal taxable wages and it lists Maryland taxable wages. Those wages, as far as the Comptroller of Maryland is concerned, are taxable.
Well, we're not talking about a disembodied entity called. We're talking about Sion as the one who made the determination. Now, she's already stated, and I just wanted to clarify because there was a little talking over each other, that I believe she said she wasn't. She wasn't qualified or she wasn't authorized to determine my client had taxable income.
Yes, of course. That's what I meant is I cannot just come up with this data and determine that. That's why we send you a notice in demand. I cannot just make that decision by myself because I have these data. But once you do not fulfill the requirement, yes, I am qualified to send the assessment.
Okay, well, what you had said, and we'll have to play the tape and enter that into evidence, what you had stated on the phone back in October when we were trying to resolve this without having it come this far and costing my client more time and money and whatnot. We could have resolved this on the phone with you, which is why we called.
I have objection.
I'm going to step in here for a second. Would you... Let me, if I might interject into here. Let's see. Ms. Beakley, do you have any legal training? Have you ever gone to law school?
No, I don't.
You have not gone to law school. Have you ever read any court cases regarding what is and what is not taxable wages?
I only had this kind of court cases.
You've had, well, this is not a court. This is an appeals attorney.
Are you an attorney?
No,
she is not an attorney. There we go. All right. So you were...
The only objection I had was about the recording of telephone conversation he's talking about.
And actually, I would like to get this under oath. Going back to the recording, can I put Mr. under oath, or would you like to?
Well, Mr. will go under oath only to testify regarding the recording, and he will not. So any kind of cross-examination or questions directed to Mr. that go outside of that will not be answered.
Okay. All right. Can you raise your right hand, Mr. Kerr? Are you going to testify? Or you're not.
Well, just in case. Yeah.
Just in case. All right. Do you solemnly declare under the penalties of perjury that the testimony you're about to give will be true and correct to the best of your knowledge, information, and belief?
Yes.
Okay. Did you speak with Ms. Beakley on the telephone?
Yes.
Did you? When were the approximate dates that you spoke to her?
I'm going to rely on Marc's memory because I don't remember the exact dates. But
I have the record. It was October 13th, 2010. October
13th, 2010. Okay. Was this a conference call between Mr. and Mr. Kerr and Mr. Stevens?
No, it was a conference call between Mr. Stevens, myself, and Sion.
Okay. All right. So those were the three parties. Mr. Stevens, where were you when you called into the comptroller's office?
I was in Phoenix, Arizona.
Okay. Mr. And where were you present at?
I'm trying to remember.
At your home? At your home, or
Maybe, I don't recall.
At your home?
I don't recall for sure.
Okay. Have you traveled outside the state? Did you travel outside?
I travel outside the state every day.
Every day. Okay. Let me see. And you stated that that phone call on October 13th, 2010, between Mr. Stevens, Mr. and Ms. Beakley was recorded. By whom?
That was recorded by myself.
That was recorded by you.
Yes.
Let's see. And was Ms. Beakley aware that the recording was occurring?
Ms. Beakley was not aware of my recording, but she had to have been aware of the recording from the department she worked for, as all incoming calls are recorded.
Yes, Ms. Beakley, are your phone calls recorded?
No, they're not.
Let's see. Were you aware that the phone call was being recorded?
Absolutely not.
Absolutely not. Okay. What I'm getting at is that I'm not familiar with the statute, but it is actually a crime to record a conversation a telephone conversation without the other person's knowledge. I don't know about what that statute is.
I'm actually, sir, in Arizona, and in Arizona, only one of the parties needs to know, so it's not considered a crime in Arizona.
Okay.
And given the fact that I do not believe, because every time you call, let's say for the IRS, for example, there's a recording, and I would have to listen to the recording we have, and even if we record at that point, that when you do call government, especially tax agencies, that there is a message that you get before you're connected to an operator or another human being that the call is being monitored and recorded for, and what they say is quality control purposes, but the calls are recorded.
There's also the issue that she's working in a public capacity, and so there are some issues as to whether or not she can have any reasonable expectation of privacy when she's dealing in a public capacity to a public person.
Duly noted. Let's see. I'm looking at the timer on my telephone, and it's been 1 hour since I guess the phone call started. I'm going to give another 15 minutes for this test for the hearing. It's generally allowed 45 minutes. We've gone over that. Is 15 minutes enough for you to make your presentation?
Well, it depends on objections or whatnot. Is it possible that we could reschedule and finish if we can't?
I'm not going to reschedule this. I'd like to actually get through because I'm not sure what transpired in the last hearing or so-called hearing. All right, let's get through. So there was a recording conversation. There was a recording. Let's go back to where we're at. There was a recording of the conversations, and Ms. Beakley stated what? I'm just going to say that we'll take Mrs. Beakley's testimony as it is, that whatever she said on record, and you have a recording of it, and we can give a copy of it. Did you have any further questions?
Yes, I do. I wanted to ask Mr. to confirm that Sion did state that she was not qualified to say the income was taxable, and that no one at the department could determine it was taxable.
That is correct.
And then we followed up with a letter to that, because we had spoken to her supervisor that day, Ms. Barmuth, that we stated that there was no witnesses that with personal knowledge that you're a taxpayer and have an obligation to file. We established that she was not qualified no one was qualified to say the income was taxable. We wanted the threatened action to be abated, and they said put it in writing. We did. They never responded, and then we got a notice of a hearing. I mean, that's your recollection of what happened.
Okay.
And you have the paperwork that we had sent to.
I'm not familiar with the letter you're talking about, Mark.
Well, we had sent a letter asking them to telling them what had happened on the phone, and that we wanted it abated. And then in response to that, instead of trying to resolve it, they just went ahead and did an assessment.
Okay, we've got the assessments on here now. Your first and one of your main arguments is that she did not have evidence or data, and that she was not qualified to make the determination that there were wages. Is that your argument or your contention? Is that correct, Mr. Stevens?
is, and we have, of course, the phone call, Mr. testimony to confirm that, and I would still like to question in the time we have left. I'd like to question Sion further.
Okay. Did you have any? I mean, because of what I was saying, I'd like to give about I'll say 20 minutes, and if 20 minutes is good with you, do you have other, I guess, points or arguments that you're going to be driving at, other than that she made a statement or that she was not qualified to make an assessment? Is there?
Well, I'd like her to confirm that, and I'd like her to confirm it clearly.
Okay. All right. Well, all right, Ms. Beakley. Well, we have the ask your question.
See, now you've already stated that you're not an attorney. Are you required to be an attorney to do your job?
No, I don't. I'm not.
Okay, and your job requires you to make legal determinations based on Maryland law and federal law?
Yes.
Okay. Did you determine that Mr. is a taxpayer under Maryland law?
Yes.
You did. Did you determine that he had taxable income under Maryland law?
Correct.
Okay. Did you determine that he had an obligation to file a return under Maryland law?
Yes.
Okay. And for 2005 to 2009, you had no information to current information. All right, let me rephrase that. For 2005 to 2009, you had no information for 2005 through 2009 to base your assessments on.
I only have residency information.
Well, just be clear. You had no information for 2005 to 2009. You had no information from 2005 through 2009 for those assessments.
Sir, I only had residence. I only know.
I think, Mr. Stevens, that we've established that we had that there was no data. There was no data or no evidence.
Okay.
That.
Okay. So again, just like on the phone call, I want to ask you: is there a factual difference between income and taxable income?
To your knowledge.
Correct.
There is. Do you know what those are?
Yes.
Okay. Are they present in the assessments? Did you have those facts available to you when you made these assessments against Mr.
Yes, I did.
You did. Now, my question, before we get into what those facts are, why didn't you discuss that with me and Mr. Putnam on the phone when we first spoke to you to try to resolve this?
I'm going to say, Mr. Stevens, that let's talk about the what has been presently issued. Did you talk with him or not talk with him about the facts? To the best of your knowledge.
To the best of my knowledge, I responded.
She did. She, to the best of her knowledge, she gave the presentation that she had available to you on the phone.
Well, I can testify that she presented no facts.
Okay.
Yeah,
all right.
Mr. Just say for the record that Miss Sion is incorrectly stating the facts.
Okay. You've made that presentation. Yeah. Okay. You've made your statement.
I've made my statement, and before I move on, I think just based on inconsistent testimony, I would say that she is not a reliable witness, and we should strike her testimony.
I'm not going to strike her testimony because, she's the only person that's actually, not anymore. She has sworn under oath, and that there's no rules of evidence as far as this appeal hearing goes. You can object to the veracity of the testimony, but as far as striking the testimony in and of itself, we're not going to strike it, but it's credible for what it's worth.
It's credible for what it's worth. You're going to have to explain that to me because she's now been shown to be incorrect several times, and she's already been inconsistent testimony. While we may not have formal rules of evidence, if my client is entitled to a fair trial, part of having a fair trial is having a witness that you're going to base your decision on that is giving clear, concise, consistent testimony. And she's been rebutted several times now.
I base my decision based on the testimony that's given, whether I find it's credible or not. If I find that their testimony is not credible, I'll give it its due weight. If I do find that it's credible, I'll give it its due regard as well. It's basically a determination about what I feel, or how weighty her testimony is.
So you're not willing to make a decision right now on the weight of her testimony?
I'm not willing to make a decision based on when we're going back to the presumption that the assessments are incorrect based on this Portillo and Janus court cases. That's the first thing I needed to do to make my decision. I'm not going to make a decision today because I don't have copies of his court opinions.
You want me to email those to you?
You can email them to me. Yes, absolutely. Mr. Has kindly offered to email those decisions to me.
Okay.
So, all right.
Okay. Well, to get back, she stated on the record that there were factual differences between income and taxable income, and that she knew what they were. I'd just like Sion, I'd like you to tell me what those factual differences are.
All right. I am noting that.
Social Security isn't taxable. Disability.
According to the Maryland law, the Social Security, the savings bond, and disability are not. Wages, such as the one we had for Mr. in our system, is taxable.
Is that legally or is that factually? Because I believe you're basing that on the law, not on facts.
That's under the law of the state of Maryland.
I'm sorry, I couldn't understand that.
That's under the law of the state of Maryland.
Facts under the law. Well, I'm not asking you about the law. I'm asking you about the facts. Are there facts independent of the law?
I'm not really sure what you're asking.
Yeah. Mr. Stevens, how about if we just, if I can probably summarize your testimony or summarize what you're going at, that you don't believe that Ms. Beakley is qualified to make a determination whether the assessment was correct or incorrect, that you don't believe that she has is qualified to determine what is wages or what is not wages, and that you just essentially think that the issuance of the assessments to begin with was improper. If I were to make those three statements, would you agree with those?
No, I wouldn't agree with all those.
You wouldn't agree with them?
No, well, I think what I'm getting at here is that I'm asking her about the factual differences between income and taxable income, and she says there is. I want to know what those facts are, but she keeps going to the code.
Let me ask her what I'm going to ask her one question, and then you'll be allowed to ask her one question, and then I'm going to wrap up the testimony. Ms. Beakley, in your opinion, or based on your understanding of the law, what kinds of income do you feel are taxable wages, just off the top of your head?
Wages. The ones.
What do you think are taxable? If you got
what are wages?
Hold on. Excuse me. If I received a paycheck from the state of Maryland and I received a paycheck for $100,000, would you consider that to be taxable wages?
Correct.
Or taxable income?
Yes.
Yes. Okay. Number two, if I received a paycheck from the federal government for $100,000, would you consider that to be taxable wages or income?
Correct.
If I received $100,000 as from ABC Corporation, would you consider that to be taxable in wages or income?
Yes.
If I received Social Security disability or Social Security payments of $10,000, would you consider that to be taxable wages?
No.
If I received a bond interest of $10,000, you wouldn't, and that was the bond interest came from the federal government from the holding U.S. Treasuries.
No.
Okay. All right. But
Okay, so I have a question here, because before, you're asking all these questions, right? Mm-hmm. And before, when we spoke to her, she said that she was not qualified to make a determination as to what was taxable income.
We have, I think we thoroughly...
out of her own mouth, she said that.
Okay.
So she's already impeached herself. And now you're asking questions like she's an expert.
I'm just trying to determine what she thinks is taxable wages or taxable income.
But that doesn't negate the fact that she admitted herself that she was not qualified to do so.
I think Mr. Stevens and Mr. I'm going to stop the line of questioning here. I think you've basically made your point in my mind. I understand what arguments that you're driving at, and that's clear in my mind. Do you have any separate arguments other than she isn't qualified to understand what federal taxable wages or federal taxable income are?
But the other issue is that she doesn't have any evidence. We've already...
Evidence. That's the other argument.
Well, it's more of an observation, but that there is no evidence. I mean, I'm sure I'd like to ask her if she was able to prove the income was taxable using just facts.
I don't think that we're going to stop the questioning there.
That's a pretty important question, though.
Okay, but we're going to stop it there. I think
I'm going to object to that. I think we're getting to the heart of it, and
This is where the conflict now comes in. And now from sitting at this end, you can see now where I wouldn't feel comfortable having somebody with a conflict of interest making a determination about my situation.
So you object to the hearing itself?
I object to the whole thing because I can see now that you are biased.
Okay.
Okay.
That's your objection.
That is my observation.
Did you have any other evidence or testimony other than questioning Beakley, Ms. Beakley?
I don't have any. Do you have any more?
Just what we've pointed out, and Mr. Maskus, you've been a lot more accommodating professional than a previous hearing officer. Why we stop it at this particular point when that's such a pivotal question? Can she establish with just facts that the income is taxable?
Because if you've ever had to go into a court, judges will stop a line of questioning when they think that the point has been made. I understand what your points are. Believe me, by the questions that you are driving at, I have the broad scope. There's a certain point where I just think that you're badgering someone, and that's my opinion.
So you think I'm badgering Sion?
I think you're but I think we're starting to get into that point. And what I think is best is that I'm going to get the court cases from Mr. Kerr. He's going to kindly email them to me. I'm going to take a look at your presumption arguments. We have an argument on the table that there's an argument, and if just to make you happy, that there was a statement that there was no evidence for 2005 to 2009 that there was any wages, or at least there was no evidence in the computer system or that what she based her assessment on. That's correct. That's there.
I'm also going to say that the only evidence you have for the other years is computer records indicating a financial transaction, and there was no determination of whether it was taxable income or not.
Mr. Stevens, Mr. Kerr, have you been provided copies of the printouts that Ms. Beakley used?
I think I probably have.
You have, so that you do have some sort of piece of paper that shows
it's just a computer record. That
okay. All right.
It's just a piece of paper.
All right.
I just want to point out, too, that under cross-examination, if we call it that, or under questioning for myself, Sion did state that there were no witnesses with personal first-hand knowledge that Mr. the taxpayer with taxable income, and that he's required to file. That would include Sion, who made the assessments.
All right.
So I want to make sure that is something that is considered in your determination, that if you're going to base something off of her, you have to know she has no personal knowledge of these things. And that if we were in court with formal rules of evidence, which I feel should, out of fairness, should apply here, that in and of itself is all that is legally necessary for you to throw this out.
Okay. So presumption, no data, evidence for 2005 to 2009. You dispute 2002, well, 2000.
And you are putting in that these are factual disputes.
Yes.
Okay,
yes.
Thank you. I want to make sure that that's part of the record.
I'm just going with the broad. There's the presumption dispute. There's the presumption that or the dispute that there was, or actually the statement that there was no data or evidence for 2005 and 2009. 2002 to 2000 and also 2004 dispute that essentially the evidence or the financial transactions were taxable wages, taxable income, or anything that would lead to an assessment. There was no witnesses for Ms. Beakley.
And there was no one with any qualifications to make a determination.
And no qualification. Would that be the four arguments? And Mr. Curtis?
I believe that the Janus and Portillo cases, United States Supreme Court, established that for an assessment to be deemed prima facie correct, there is a threshold, and it's not. There does exist a threshold.
Okay.
So it's not necessarily automatically prima facie correct.
All right.
And so those are the cases I'll send to you directed by Mr.
Yeah. And if you have my email address, and if you can copy Mr. on it and copy Mr. Stevens as well. I have those four basic arguments outlined here. I'm, of course, going to listen to the tape and review what's been said and what evidence we have. Is there a fifth or final or broad-based argument other than presumption, the data at hand, the lack of witnesses, and the lack of qualification?
I don't have any. I think that's it. If you have something.
No, I think that pretty much covers it.
Are you satisfied that this was that you were entitled to a hearing? I've been Mr. has indicated that he doesn't think that it was you've indicated that it was a biased hearing, but are you satisfied that a requirement that there has actually been a hearing has been met?
I believe that there was a hearing, and I believe that you were fair up to a point. We object, of course, and you've noted that stopping the questioning at such a critical point. And I object that I want you to note that we do object that I had engaged in any kind of badgering of Sion.
Okay. Now, it started to get down to that, it started to get that point, and at a certain point, when I understand what you're driving at, the number of questions or the questions that you're going to ask offers me very little as far as information that I can use.
Well, I did that because you insisted on... Yeah, because I had moved to strike her testimony as an unqualified witness, even by her own admission, and you seemed that you wanted to still take her testimony, or you would not, or at least during the hearing, you would not commit to a position on the weight of her testimony.
Yeah, well, that's fair enough. So, Mr. Stevens, is there a contact number that I can reach you at? I mean, I don't. You have my contact information, but I don't have yours. Is there a phone number?
Sure. You ready?
Yes.
602 74.
Okay, and that's Mr. Stevens.
Yes.
Should I talk to you solely, or should I talk to Mr. Putnam or Mr. Kern, other than the email communication?
I'd rather have you talk to Mark.
You'd rather have to talk to Mark? Okay. All right. So I think that wraps it up. I think we've got our arguments on the table. I think we've gone through, and I think we've highlighted what the facts, circumstances are of this case.